Hi everybody, I'm Susan Bio, the lawyer for your business, and today we're talking about buying a business. And our first topic is what are you really going to get at the end of the deal? So when you start negotiating the purchase of a business, it's really important that you be extremely clear on what it is you're buying and how to refer to that so that all of the parties to the transaction understand what they're getting, what they're selling, and they're speaking the same language. So some thoughts on the process. First of all, there are three different things that you can really get when you're doing a transaction to acquire business of some kind. The first is a stock sale. That's where you're buying some ownership or possibly all ownership interest in the entire business, which encompasses liabilities and assets. So you're buying the whole shoot and match, you're just buying the stock, and you're stepping into the shoes of the previous owners. You can also buy some or all of the business assets. There are challenges related to this that we're going to discuss in a minute, and you just need to be aware that when you have in mind that you're just buying the assets or that you don't want to take on the liability and that you want to take those assets and fold them into your own business that's separate from the company or the entity that holds it now, again, you just have to be really clear when you're negotiating that, what it is specifically that you're going to get. And then finally, you can just buy a line of the business, and the company or the business that's selling you that line will continue on doing work in other lines. So they're not going to disappear off the face of the earth, but they won't be a competitor of yours anymore. And again, very important that you understand the whole process of negotiating those kinds of restrictive provisions about competition and so on. Actually, sort of any of these deals, that's a really good idea. But let's talk about a stock sale. As we mentioned, when you're buying an ownership interest, and I'm going to call it stock for convenience, but if you're buying it from, say, a limited liability company, it might be called units, it might be called percentage of ownership or some such thing, but ownership, when you're buying ownership of the company, you take it as it is, good, bad, and different. You get it, you got it, you deal with it. So before doing that deal, it is very important to get a really great valuation expert to go in and tell you what's really going on with the books. We've seen situations where people fluff up the revenue numbers, people downplay the extent of the liability. So it's real important that you get experts to come in and evaluate what's it going to end up looking like, from the liability perspective, so you can accurately price it, among other things, and that you can prepare yourself if any of that stuff comes to fruition that hasn't already. Another way is that you can just buy some assets from a concern that's going. Those assets can be both tangible and intangible. Intangibles would be like domain names and trademarks and various intellectual property matters, relationships, client lists, or it can be hard assets, if you will, like capital assets, trucks and land and buildings and things like that. So you can buy a few or you can buy them all. Either way, you've got to do some due diligence there too, just to make sure that they're not encumbered by debt, that they're not being used as security for a debt. And you need to worry about a concept called de facto merger. If you purchase all of the assets, the law may just deem that you actually bought the whole company, whether you intended to or not. So structuring these deals properly is very, very important. And it's a good idea to talk to somebody before you even begin the negotiations to help you sort through some of this stuff. And the answer to whether you're going to buy the stock or whether you're going to buy the assets may vary depending on the target. The last alternative is you buy a line or two of just a line of business or a division of a going concern. And effectively, that means the company you're buying it from is just divesting themselves of something they don't want to do anymore. Maybe it's lucrative, maybe it's not lucrative, or maybe they just need cash and they've got to sell something, and that's the line they chose to sell. For example, if Google sold only YouTube, That's a division, that's a line of business. Google's going to go on doing all sorts of other business, but that particular line of business now would belong to someone else. And what you get with that line of business can vary. Sometimes it's just intellectual property, again, client lists, that kind of thing. It could also be employees. It could be a whole lot of stuff. So it really depends on how the original, how you approach it depends on how the original business was treating that line of business or that division. And it kind of depends on all of the other stuff we've already talked about. So again, it's a good idea to get some professionals involved fairly early in the process, perhaps before you think you really need them. So long before anything goes on paper, long before anybody shakes hands, and please, please, please don't say we have a deal until you've consulted with someone. Some of those oral agreements can end up being binding as well. So anyway, with that happy news, we're going to go ahead and sign off, and catch us again next time. We're going to talk about the best structures for liability protection and tax goals. Okay, until next time.